I'm Cordell Johnston, attorney. Until a couple of months ago, I was Government Affairs Counsel at the New Hampshire Municipal Association. I have just retired from that position and now am working on my own as a municipal attorney with a kind of a part-time practice representing a small number of municipalities. And it's great to be here this morning. Nice to see some familiar names on the list of participants. And I'm going to talk about short-term rentals, which I think probably everyone is familiar with by now. Some people just refer to them as Airbnbs, which I strongly encourage you not to do. Airbnb is just one company that operates an online platform for marketing short-term rentals. It is not a generic term. And there are other companies like VRBO and HomeAway and others that market short-term rentals. And a lot of short-term rentals don't even use any of those platforms. Yeah, you know, I've even heard people use Airbnb as a verb, as in, I think I'm going to start Airbnb-ing my house. And that just makes me want to scream, not because of any objections to Airbnb, but just because of my concern about mangling the English language. Because whatever else Airbnb is, it's not a verb. So just, I guess maybe as a personal favor to me, don't use Airbnb as a verb. Anyway, the point is that we're talking about a use of property, not a particular company. Short-term rentals existed long before Airbnb or any of the other companies that market them. If you think about the cottage on the lake that your family has rented for many years or even many decades, or the condo that you may have rented for a ski vacation, that was a short-term rental. And obviously those have existed for a long time. It's just that they've, with the advent of the online marketing platforms, they have become a lot more popular and a lot more conspicuous. Now, a little bit about my perspective, and it's possible that I'll come across as biased against short-term rentals during this presentation, and I am not opposed to short-term rentals. I even have used them occasionally myself, although I try before I rent one to make sure that it's being operated in compliance with local regulations. But I have developed a perspective based on my experience at the legislature. I mentioned I was at the New Hampshire Municipal Association. I was there for 18 years, and my job there as Government Affairs Counsel was to represent the interest of local governments, all of New Hampshire's cities and towns, before the state legislature. And so essentially, I was there trying to protect local authority and local control. And in the last, I'd say 5 to 6 years, there have been many efforts at the legislature to preempt local authority over short-term rentals and essentially exempt them from zoning. And that those fights have been kind of contentious sometimes, and so it has certainly given me a certain perspective. But again, I do not have any objection on principle to short-term rentals if they are done properly, and that's the issue, is whether they're done properly. So let's start by talking about what is a short-term rental, and there is no controlling definition. It's I think we all pretty much understand what a short-term rental is, and it's sort of like former Supreme Court Justice Potter Stewart's what he said about hardcore pornography. I can't define it, but I know it when I see it, and that's not to compare short-term rentals to pornography by any means. It's just, we know what it is, but it's not always that easy to define. But basically, as I say in this slide, it's the rental of one or more units for lodging accommodations up to a certain number of days, typically in a building that would otherwise be used as a residence and may or may not include access to cooking facilities. And some of these are in owner-occupied homes, and some of them are not. And again, there's no controlling definition in state law as to what a short-term rental is. To the extent that it is defined, it needs to be defined in your local zoning ordinance. Historically, most zoning ordinance didn't have a definition of short-term rental. They existed. Talk a little bit more about that later, but really there wasn't a definition. In the last decade or so, some towns have started to put a definition of short-term rental into their ordinance, and I just pulled out a couple examples that I am aware of from towns that have defined them in their ordinances here, and I have those examples up on the screen. I'm not going to read them to you. I am sure that you can read, but as you'll see, one of these ordinances draws the line for a short-term rental as at 14 consecutive nights. The other one does it at 30 days, and there are varying definitions, anywhere from 14 up to 182 days. And it really it depends on the ordinance, and it depends on how you want to define it. So the first question that well, I guess that was the first question. What is a short-term rental? So the second question is, can municipalities regulate or prohibit short-term rentals? And this is not a hard question, and yet it has gotten a whole lot of attention because some people have tried to make it a hard question. There is no question that municipalities can regulate or prohibit them. The zoning enabling statute, I'm sure most of you are familiar with it, RSA 674-16, says that municipalities can adopt ordinances to regulate and restrict the location and use of buildings, structures, and land used for business, industrial, residential, or other purposes. That is extremely broad. It covers pretty much everything, and clearly it covers short-term rentals. So do not let anyone tell you that your town cannot regulate short-term rentals. And we'll go through some of the arguments that you may hear about why you don't have authority to regulate short-term rentals. The first argument, or maybe not the first, but one of the arguments that it kind of sounds good is there's the statute RSA 48A that says that this statute shall not be used to impose any additional restrictions on dwellings used as a vacation rental or short-term rental. And some in the short-term rental business have cited that statute and said, look, right here, RSA 48A says you can't impose any additional restrictions. Well, the answer to that is that limitation applies only to the housing code statute. It has nothing to do with zoning authority. And I don't know how many of you are familiar with the housing code statute. I'm not sure. I haven't taken a survey, but my guess is that it's a fairly small minority of New Hampshire municipalities that actually have a housing code adopted under 48A. I think the cities and some of the larger towns have housing codes, but I think most medium and smaller sized towns don't. But in any event, the limitation in 48A applies only to what you do under 48A. It doesn't apply to zoning authority. And in fact, I was there when, and this is one of the benefits of my prior job, I was there when that section of the statute was enacted, and it actually came out of a bill that was aimed at prohibiting municipalities from regulating short-term rentals. And we fought that quite hard, and we ended up with this compromise that put this language only into the housing code statute. And in fact, we got the committee of conference that took the final action on this bill to include a statement in the legislative history that says everyone agrees that cities and towns are free to regulate vacation rentals under RSA 674 planning and zoning. And on the screen there, I cite the book and page where that statement appears. So it's absolutely clear that that provision in RSA 48A doesn't affect zoning authority at all. Another argument, and this is the argument that I've heard most of all, I think, is that, well, a short-term rental is a residential use. It's no different from a long-term rental, and it can't be treated differently. My answer to that, I said hooey only because I probably shouldn't use a stronger term, but that really is a ridiculous argument. A short-term rental is not a residential use. Guests do not reside there. I mean, there is an obvious difference between a short-term rental and a long-term rental. If you have a house or a building and you rent it to someone and you have a 6-month or a 1-year or 2-year lease or something like that, the person or the family that you're renting it to, they move in, they live there, they bring, their kids and their pets and their furniture. That becomes their residence. And so it's obviously a residential use. If you rent your house every weekend or every night to a different person or a different group of people, those people don't live there. They don't reside there. And in fact, RSA 21, that's the chapter that contains the generally applicable definitions under state laws. 21(6)A defines residence as a person's place of abode or domicile, and it goes on to talk about the place that they plan to make their home. A short-term rental guest would never try to claim, or I hope would never try to claim domicile, for example, for voting purposes. And then there are various other statutes that draw clear distinctions between short-term rentals and long-term rentals. There's the Meals and Rooms Tax Statute, RSA 78A, the Hotel Statute, the Landlord-Tenant Statute, and they all treat short-term rentals as a commercial use, and they treat long-term rentals as a residential use. As I say, basically a short-term rental is a hotel. And in fact, if you look at the definition of hotel under the Meals and Rooms Tax Statute, it includes a number of things. One of them is the term is tourist homes, but it clearly would include anything that you think of as a short-term rental. So the claim that a short-term rental is residential and can't be treated any differently from a long-term rental, that is, as I say, hooey. Another argument you'll hear is that trying to restrict a short-term rental is an unconstitutional taking of property without compensation. That is someone trying to play lawyer without having gone to law school, or I hope someone who's gone to law school wouldn't make that argument. Although, in fact, I have heard it made by people with law degrees, but that's silly. That argument, as I say, was settled over 100 years ago. If you think that's an unconstitutional taking, then you must think that zoning is an unconstitutional taking, and maybe that was a legitimate argument at some point, but the courts have long since disposed of it. The next argument is selective enforcement. Someone will say, well, you have a zoning ordinance that prohibits short-term rentals, but you've never enforced it, and now you're trying to enforce it against me, and that's improper. That's selective enforcement, and that could be a legitimate argument. But understand there's a difference between selective enforcement, which is bad, and historical non-enforcement. if your ordinance doesn't allow short-term rentals, but you've never enforced that prohibition, and now because of complaints you're getting or whatever, you start to enforce it, that's not selective enforcement, as long as you now start enforcing it consistently. If you now enforce it against some property owners but not other property owners, yeah, that's selective enforcement, and that property owner may have a good argument against you. But the fact that you historically haven't enforced it, that's not selective enforcement, and that doesn't stop you from enforcing it now, as long as I say, you do it in a consistent way. You're not intentionally discriminating against somebody. And then the last argument is my short-term rental is grandfathered. And it's possible that that's the case, but probably not. A lot of people misunderstand what a grandfathered use is. A use is grandfathered if it was legal at the time it was established, and that's a big if. If you've been renting out this cottage on the lake for 50 years, and the town only adopted a zoning ordinance 25 years ago, and that ordinance prohibits short-term rentals, but you were doing it long before that, yeah, your use may be grandfathered. On the other hand, if the ordinance has always prohibited short-term rentals, and you started your short-term rental operation after the ordinance was adopted, but it was never forced against you, you don't have a grandfathered use. What you have is you have gotten away with an illegal use for any number of years. It doesn't become grandfathered just because you've done it for a certain period of time. It had to be legal at the time you started. So, and then to the extent there was any real argument about whether municipalities could regulate or prohibit short-term rentals, that was essentially settled 3 years ago by the New Hampshire Supreme Court, in this case, Working Stiff Partners versus Portsmouth. And I'm going to talk about that case a little later in the presentation, but the court upheld the city's determination that a short-term rental was a transient occupancy, not a dwelling unit, and therefore was prohibited under the zoning ordinance. It didn't directly address the argument, well, does the city have the authority to do that? Can it prohibit short-term rentals? But the court's opinion clearly recognized that the city does have that authority, and it has the authority to treat short-term rentals differently from residential uses. So there is no question about it. And as I said, don't let anyone tell you that you can't do it. Now, the next question is, should you regulate or prohibit short-term rentals? And that obviously is a different question. And I'm not here to tell you that you should. As I said, I'm not anti short-term rental, and the point of this presentation is not to say that you should be prohibiting them or that you even should be regulating them. Whether you want to do that is an entirely local decision. It is something that is more likely to be a concern in certain parts of the state. It has been a major issue, as I'm sure a lot of you know, especially in the White Mountain region, and especially in the Mount Washington Valley in Conway and some of the towns in that area. Also in the Lakes region, Guilford, Laconia, and several cities and towns in that area have been dealing with short-term rentals. Seacoast, basically anywhere, any part of the state that is likely to have a lot of tourists or vacationers, but it could be an issue anywhere. And so you need to decide whether it's an issue, and in doing so, you think about what some of there are both benefits and problems that come with short-term rentals. The benefits, tourist activity, to the extent you think that's a good thing. You know, that you've probably all seen the bumper sticker that says "Welcome to New Hampshire, now go home." People have mixed feelings on how good, how much of a benefit tourist activity is to their municipality. And I think, you know, everyone likes the idea that tourists come to New Hampshire and bring their money and spend their money, and it's good for the state economy. But a lot of people think it's good as long as they go to another part of New Hampshire and don't spend all their time in my town. But it brings tourist activity. It can bring income to homeowners to help pay their property taxes, and that's an argument people often make in support of short-term rentals. Although, as I say here, that claim is wildly exaggerated because I think at this point most of the short-term rental owners are not really homeowners renting out one or two rooms in the home where they live. They're people who have bought property for the sole purpose of renting it out as a short-term rental. So the argument that I need this income to pay my property taxes, it does have some credibility, but not always. And then there are a number of concerns that come with short-term rentals. And I know some of you are from towns that have experienced these problems with disorderly conduct by guests at short-term rentals, people disposing of trash improperly, in overcrowded houses, loud parties, and the strain on municipal resources, police departments having to respond to complaints, and then the overuse of water and sewer systems. I know I read about that in Guilford, concerned by the town that in one particular part of town, the sewer system usage of the system had increased by a significant amount because of the short-term rentals. And then the other thing is the effect on the long-term housing market. Everyone knows that we have a housing crisis in New Hampshire. Housing is very hard to find, and when you can find it, it's not affordable. And if people are buying houses and turning them into short-term rentals, that every house that is used in that manner is one house that is not available for the residents of the town and residents of the state. So, and I can't prove that there has been a significant effect on the housing market in New Hampshire, but I think it's fairly intuitive that it would have some effect. So those are the things that you need to think about in deciding whether you want to be regulating short-term rentals. And so let's assume that you at least think that this is a conversation worth having. And so where do you begin? I think you begin by identifying exactly what the issues are in your town, in your city or town. Do you have a problem currently? And the most pressing problem that you might have is your ordinance doesn't allow short-term rentals, but people are operating short-term rentals. And it may be that it's just a new problem that occurred, or it may be that, you know, I talked about historical non-enforcement. And it could be that the town never enforced it because there wasn't a problem, but maybe now there is a problem, either because the short-term rentals that did exist are now becoming, you know, they're being used more often and more abusively, or because maybe in the past you had 3 or 4 houses in town that were used as short-term rentals, and now they've become so popular you have 40 or 50 and it's starting to get out of control. So if that's the case, you need to think about what you're gonna do about that. The situation may be that the ordinance doesn't clearly prohibit short-term rentals, And so people are taking advantage of that unclarity and saying, there's nothing stopping me, so I'm gonna operate this property as a short-term rental. And then the situation may be that they actually are permitted, but maybe your ordinance has always permitted them, but it was never a problem. But now they are causing problems. So the ordinance may prohibit them, may allow them, but for whatever the case is, they may be starting to cause problems. And then on the other hand, you may not have any problems in your town right now, but you've read about what's happened in Conway or Guilford or Portsmouth, and you're thinking, we'd like to get ahead of the problem rather than be reacting to it when it becomes a problem. And maybe you're not sure, as you think about that, you're not sure what your ordinance allows. And I'd be willing to bet that most people that are involved in planning and zoning in their municipalities are not quite sure, unless the issue has actually been raised, are not quite sure what their ordinance allows. I'm not sure whether the ordinance in my town allows short-term rentals, and we're actually going to talk about that in a couple of minutes. So that's where you begin, figure out what your issues are, and then once you have an understanding of what your concerns are and what the concerns of your town are, you're in a position to start doing something about it. As you think about this, keep in mind that there are different kinds of short-term rentals. And I've listed 3 basic kinds, and I'm sure there are variations on these. The first one is owner-occupied. That's where the owner is a full-time resident. So let's say I have a 4-bedroom house that I've owned for 20 years, but my kids are grown, they've moved out, my wife has moved out, and it's just me living in this house. And I decide that I don't need 4 bedrooms, but I don't want to sell the house, so I decide I'm going to rent out 1 or 2 bedrooms and make a little money, but I'm still going to be living here. So that owner-occupied short-term rental is the one that's probably least likely to create problems, because if I'm living in the house and I'm renting a bedroom, down the hall from mine, or I'm renting maybe a space above my garage, I'm there to keep an eye on things, and obviously I care about what happens to my property. Second type is the seasonally owner-occupied, and that's where, again, maybe I own this house, but I go to Florida for 3 months out of the year, January through the end of March. And I figure that I could rent my house out during that period, maybe to skiers. As it happens, I live in Henniker, a town that has a small ski resort, Pat's Peak. And so maybe I could rent my house from January until Pat's Peak closes at the end of March. And that's, again, if it's my house and I'm coming back at the end of March and I'm going to be inspecting the property, I probably am going to be very careful about who I rent the house to, because it's still my house and I still care about it. And just as important, I care about not alienating my neighbors, because obviously they don't want a bunch of strangers coming in and ruining the neighborhood. And then the last category is the non-owner occupied, and that's where you have an absentee owner who rents the property full time, and that's where I decide I'm going to sell my house, or maybe I don't sell my house, but I move, I buy a different house, and now I live somewhere else, and I'm just going to rent my house, and I'm going to rent it on a short-term basis. I'm going to rent it to, by the day, by the week, or whatever. And it's going to be a constant parade of people coming in and out. And I only show up, maybe once every couple of months to make sure that that the house is still standing. Basically, as I say here, I've turned it into a Holiday Inn without actually putting up a sign. Um, and this has become, I think, probably the most common form of short-term rental with investors, and there are a lot of examples of this, and frequently out-of-state investors that are buying houses and turning them into income properties. So whatever you're going to do, if you're looking at trying to address short-term rentals, you need to start with the language of your existing ordinance. Because remember, at the beginning I said historically most, if not all, ordinances didn't have a definition of short-term rental in them. But that doesn't mean that they don't have language in them that could be read to apply to short-term rentals. And it is entirely possible that your ordinance already prohibits short-term rentals without explicitly using that term. Now, as I say here, most municipalities have what's called a permissive zoning ordinance, and a permissive ordinance is one in which any use that is not expressly permitted in the ordinance is deemed to be prohibited. And the term permissive zoning ordinance kind of sounds like the opposite of the way it's defined, but that's what we call it for whatever reason. And the typical language in an ordinance like that would be probably at the beginning of the ordinance, and it says something like, no building, structure, or land shall be used except for the purposes permitted in the districts as specified in this ordinance. Any use not listed shall be construed to be prohibited. So in an ordinance like that, typically you would have, you'll have a list of all of the permitted uses in the town, and you may have one master list for the whole town, or you may have a separate list for each zoning district, because you probably have more than one zoning district. So for a particular district, you might list the following uses are permitted: single-family dwelling, two-family dwelling, multifamily, retail store, agriculture, et cetera, et cetera. And anything that's listed there is permitted. If it's not on that list, then it is deemed prohibited. And that's how a permissive zoning ordinance works. Some municipalities have a prohibitory ordinance. It's the opposite, where any use that's not expressly prohibited is permitted. So those ordinances will list things that, or identify things that are prohibited. And if it's not among those things that are prohibited, it is deemed to be permitted. And you can probably understand why most towns don't like that kind of ordinance, because you have to think of every imaginable use that you want to prohibit, and that's kind of hard to do. And so that's why I think most towns have a permissive ordinance. But you really need to check your ordinance and figure out what kind you have, and you need to talk to your lawyer. I'm going to say this repeatedly throughout this presentation: talk to your lawyer. And it's not that I'm just trying to gin up work for my colleagues in the municipal bar or for myself. There are a lot of things that you don't need a lawyer for, but for this stuff, a lot of this stuff, you really, really need to get your lawyer involved and make sure that they know what you're doing. So you get your ordinance out, you figure out what kind it is, and then you start working through the ordinance. And I'm going to assume here that you have a permissive zoning ordinance. So the first question you ask is, what uses are permitted in each zoning district? Find the list of things that are permitted. And again, it might be single family dwelling, two-family dwelling, etc. And then, and I see if it looks the same to you as it does to me, oops, looks like I've listed 1 and 1. It's supposed to be 1 and 2. Apparently there was a problem with the translation of my document. But once you see what uses are permitted in each zoning district, you need to check the definition of each use. And can that use, that defined term, be construed to allow a short-term rental? And if you have this list of uses, and on the list of uses is school, a church, a cemetery, etc., those things you probably don't really need to look at the definition, because you can be pretty sure that that's not going to include a short-term rental. But there are other things like single-family dwelling, bed and breakfast, rooming house, boarding house, things like that. You need to go to your definition section, see how that term is defined, and can that be construed to allow a short-term rental? And as you're doing this, again, keep in mind the different kinds of short-term rentals: owner-occupied, non-owner-occupied, seasonally owner-occupied. So as an example, and I've took this stuff out of the ordinance in my town, the Henniker zoning ordinance. Our ordinance permits single-family dwellings in residential districts. And so you go to the definition of single-family dwellings, and it says a single-family dwelling is defined as a detached residential dwelling unit designed for and occupied by one family. Okay, so then you find the definition of dwelling unit. It doesn't define residential dwelling unit, but it does define dwelling unit, and it says that is one or more habitable rooms arranged for the use of one or more individuals living as a single housekeeping unit, together with cooking, living, sanitary, and sleeping facilities. Okay, so that is a definition of, that's one of the uses that are allowed in certain districts. And as I said, it doesn't define the word residential. So does that ordinance allow short-term rentals in residential districts? Well, going back to the definition, a short-term rental kind of seems to fit the definition of dwelling unit. One or more habitable rooms arranged for the use of one or more individuals living as a single housekeeping unit, together with cooking, living, sanitary, and sleeping facilities. So that kind of sounds like it, although you could say, well, one or more individuals living as a single housekeeping unit. So if I rent a house for the weekend with a bunch of my friends from college, are we living as a single housekeeping unit? We don't live together ordinarily. We're just spending a weekend there. So are we living as a single housekeeping unit? I think I would say no, but I can imagine that some other people would say yes. And then even if it is a dwelling unit, is it a residential dwelling unit? There are several different ways to look at this, and the short answer to me is it's unclear. And this is just a formula for controversy and argument about whether this provision allows short-term rentals in these districts. So if you're in that situation, I would consider amending the ordinance to clarify this. And again, talk to your lawyer. You really need to have them involved. Amend your ordinance to make it clear, and you can go one way or the other. You can amend it to make it clear that short-term rentals are allowed, or make it clear that they're not allowed. But whatever your goal is, you really need clarity to get you there without trouble. So then if you still dealing with your existing ordinance, let's say you are able to interpret it pretty clearly and it clearly disallows short-term rentals. What should you do? Well, you should enforce it. If the ordinance doesn't allow short-term rentals and there are properties that are being operated as short-term rentals, they ought to be told to stop. And I know I think most of you are planning or zoning board members, and this is not, at least initially, a job for you. Enforcement, as you probably know, is a job for your code enforcement officer, building inspector, whatever you call that person. And if you don't have such a person, for the governing body, you need to the governing body or the code enforcement officer needs to get moving and try to enforce this ordinance so it's not being violated. And to do this, you need to start gathering evidence. You probably are getting complaints from neighbors about people coming and going at all hours of the night. Maybe you can go on Airbnb or VRBO or whatever, hotels.com, and see that these properties are being rented out as short-term rentals. And then, I would start by trying to get voluntary compliance from these property owners. If that doesn't work, you may need to issue a cease and desist letter and take it from there. But whatever you do, as I said earlier, you need to make sure that you are enforcing it consistently, not just against one or two property owners and letting everyone else go. Now, the alternative, if you determine that your ordinance does prohibit short-term rentals and there are people who are operating them in violation of the ordinance, well, you might decide they're violating the ordinance, but it's not causing any harm. And maybe we should, rather than enforce the ordinance, maybe we should amend the ordinance to make it consistent with what is already being done and what nobody has a problem with. And you certainly can do that. Just go through the process of amending the ordinance. Again, you want to end up with something that is clear so that you're not going to end up in court down the road, but make it clear that short-term rentals are permitted either everywhere in town or in certain districts or under certain conditions. You could include certain conditions for the operation of short-term rentals. You could also amend the ordinance. You might decide you're going to prohibit short-term rentals, but you're going to allow the ones that currently exist. So if the amendment is going to take effect next March of 2023, you can say any short-term rental that was in operation prior to March 8th of 2023 may continue to operate. And that's the grandfathering. Now you actually have grandfathered those uses, and you certainly can do that. So you have a number of options there, but if the ordinance clearly prohibits short-term rentals, either figure out how you're going to enforce it or figure out how you're going to amend it to so that there no longer are violations. And then what is quite possibly the more likely scenario, you do a thorough review of your ordinance and you decide it's unclear whether it currently allows short-term rentals. If it's unclear and if you think that your town is a likely venue for short-term rentals, you really need to amend your ordinance for clarity. And again, I'm not here to tell you to go one way or the other. You have a range of options. You can simply prohibit short-term rentals, not allow them anywhere. You could allow all short-term rentals everywhere. Obviously, those are two ends of the spectrum. You could allow some, and if you're going to do that, most likely you're going to allow owner-occupied, but not allow others. So you could specifically say owner-occupied short-term rentals are permitted, non-owner-occupied short-term rentals are prohibited. You could allow some STRs in all districts, and you could allow this narrower set of STRs in some districts, and other districts not allow anything. You could allow them by special exception or a conditional use permit, and you could possibly have different criteria depending on the district and depending on whether they're owner occupied. And then, as I mentioned a minute ago, you could consider grandfathering existing short-term rentals if there are no problems with them. And you can have any combination of these things, or some combinations of these things. If you're gonna allow them by special exception, I just put a list here, definitely a non-exhaustive list of the kinds of conditions that you might include for a special exception or a conditional use permit, and I'm sure you can think of others. But a very important point is to remember that zoning approvals, like a special exception or a CUP, run with the land once they're granted. They stay with the property owner. So if you are going to allow them by special exception, and someone comes to the ZBA applying for a special exception for their short-term rental, and the ZBA, says, oh, it's our good friend Joe, and we know he's conscientious, and he'll take care of the property, and he's not going to cause any problems, and we'll grant the special exception to him. Keep in mind that when Joe sells the property to Vladimir, who may not be as conscientious a property owner, may not be such a good neighbor, the special exception is going to go with the property. It doesn't end when the property is sold. And in fact, it stays with the property forever unless the use is abandoned. So that is a very important consideration. I'll talk about a couple of examples of municipalities that have adopted short-term rental ordinances. Hanover has a pretty well thought out ordinance, and it's a pretty strict one. And they have distinguished among three different kinds. The first one is a hosted short-term rental, and that's owner-occupied single-family dwelling where the owner is continually present. So not only am I, if I'm the owner, not only does the property have to be my principal residence, but I have to be physically there during the entire period that the property is being rented. I can't go away for the weekend and rent the property. I gotta be sleeping there while the other people are sleeping there. And those in Hanover, those hosted short-term rentals are permitted by right in residential districts. Then they have unhosted short-term rentals. That's the owner-occupied property, but where the owner isn't necessarily there. So that's where, again, it's my principal residence. I rent it out. I go away for the weekend, and I rent my house for the weekend. It's owner-occupied, but it's unhosted. Those in Hanover are permitted by special exception in residential districts. Then they have unhosted seasonal short-term rentals. That's where the owner has vacated the premises during the period of the rental. And that's typically, again, like where I go to Florida for a few months during the year. And under their ordinance, a seasonal dwelling can only be rented for up to 182 days per year. They absolutely prohibit any non-owner occupied short-term rentals anywhere in town. And then all short-term rentals, regardless of type, have to register with the town, and there are certain additional restrictions that apply as part of that registration process. Another example is Laconia. Their ordinance is a little more generous. It allows owner-occupied short-term rentals in all districts except the industrial districts. Non-owner occupied short-term rentals, and remember, again, these are not permitted in Hanover at all. In Laconia, they are permitted in certain districts by right, and in other districts by special exception. All short-term rentals are prohibited in industrial districts, and all STR owners have to obtain a permit from the city, and there are certain conditions that apply to getting those permits. I should say, just backing up a little bit here, talking about these two ordinances, don't take what I'm saying as an authoritative interpretation of these two ordinances. This is how I read them, and also I should say this is based on how I read them about a year ago. I don't think they've changed since then, but but if there's anyone out there from Hanover or Laconia and I'm misrepresenting your ordinance, I apologize. But I'm pretty sure this is basically correct as to how those two municipalities treat them. And then there are, as I say here, at least 27 municipalities that have dealt with short-term rentals. And Noah, I believe, is going to put, if he hasn't already, is going to put on the website a link to a spreadsheet that he's prepared that lists those 27 municipalities and just a very brief description of what they've done. And I'm pretty sure he has put an appropriate, okay, he's putting the link in the chat right now. And I think that has appropriate disclaimers, kind of what I just said about Hanover and Laconia, that say, you know, it's not a legal opinion, and it's based on his quick review of the ordinance. And you need to go to the ordinance, and I strongly encourage you to do that. Go to look at some of these towns, go to their zoning ordinances, and see how they've dealt with them, because they really do cover a range from being very restrictive to being very permissive. And I think you may get some pretty good ideas. And he's posted his disclaimer there too, so that's helpful. Now, keep in mind that the zoning ordinance is not your only tool here. I mentioned both Hanover and Laconia have this requirement that you obtain a permit or that you register with the municipality. And that is based, or at least I assume in each case they based it on the statute. There's one statute for towns, 4111C, and another one for cities, 4717, that says a municipality may establish regulations relative to businesses obtaining municipal permits. So separate from the zoning ordinance, if you're going to allow short-term rentals, you can require the short-term rental owner to obtain a permit under this statute, and you can impose appropriate conditions to granting that permit. And you can consider a requirement, I think it was Laconia said, requires that the permit be renewed periodically. And I'm guessing that Hanover does too, but I can't remember that for sure. And there are a couple of reasons to do this. The first one is that the permit requirement can be adopted by the governing body. As I'm sure you all know, a zoning ordinance, a zoning amendment has to be adopted by the legislative body, and in a town, that's the town meeting. So amending your zoning ordinance is, if you're living in a town with a town meeting form of government, it's a pretty cumbersome process. It takes months. You have hearings, you know, the planning board has hearings, and then you go to the town meeting and they vote on it, and they may or may not approve it. But the business permit can be adopted by the governing body, which in a town, almost all towns, is the Board of Selectmen. It does not require a town meeting vote. The second reason for considering a municipal permit requirement is, remember a few minutes ago, I mentioned that a special exception or a conditional use permit runs with the land. And once you grant a special exception or a CUP, that attaches to the property forever, no matter who ends up buying it. But for a business permit, you can have that apply specifically to the owner. And if the owner sells the property, you can require the new owner to get a permit. And if the new owner isn't doing the things that should be done, unlike the special exception, which still applies, the business permit goes away and they can't operate the short-term rental. They still have a property. They still have a property where operation of a short-term rental is permitted, but only if they get the business permit, and they haven't done that. So you can stop them from doing it. The other tool beyond the zoning ordinance is site plan review. And I think a lot of people haven't thought about this. And again, I don't Noah may know this, but I'm not sure how many municipalities in the state have site plan review. I'm pretty sure it's a majority now. Certainly, I think almost every town in the southern part of the state has site plan review. And if your town does, then I believe that a short-term rental is subject to site plan review. The statute says that site plan review is required for development or change or expansion of use of tracts of lands, tracts for non-residential uses. And so the question is a short-term rental a non-residential use? And I think almost definitely. I mean, as I said, it's basically, at least with a non-owner occupied short-term rental, it is essentially a small hotel. It's, you know, you're advertising online. You can even find these advertised on hotels.com. If that's not a giveaway, I'm not sure what is. People make their reservations online. They they check in to a room where the housekeeper has made it up for them. They sleep there, they pay for it, they go away the next day. That's not a hotel. I don't know what is. And no one would seriously claim that a hotel is a residential use. So I think it is very clear that at least a non-owner occupied short-term rental is a non-residential use and is subject to site plan review. I would argue that even an owner-occupied short-term rental is as well. But in case I haven't mentioned this before, talk to your lawyer. Some lawyers may disagree that site plan review is required, although I will say I have talked to several lawyers about this, and they have all agreed that at least for a non-owner occupied, it would be subject to site plan review. Now, in the remaining time, I want to talk about some developments in the legal landscape, both case law and legislation. I mentioned the Portsmouth decision that came out 3 years ago, Working Stiff Partners versus Portsmouth. And Portsmouth had a permissive zoning ordinance, which I talked about earlier, which permitted single family and two family dwelling units in the residential district. And it had this definition of dwelling unit. And again, I'm not going to read this to you. You can read it yourself. But it contained this very important sentence that it shall not be deemed to include transient occupancies such as hotels, motels, etc. So the property owner in that case bought a single family house, converted it into a non-owner occupied short-term rental. City issued a cease and desist, blah, 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 ended up in the Supreme Court. And the Supreme Court held that the use of the property was for transient occupancies, similar to a hotel, and therefore did not qualify as a dwelling unit, was not permitted. Pretty clear case. You know, the property owners made some arguments that the Supreme Court rejected, but that language was pretty clear. This use shall not be deemed to include such transient occupancies as hotels, motels, etc. If you're looking for language to prohibit short-term rentals in certain districts, you probably couldn't do a whole lot better than that. More recently, September of this past year, Kearsarge lighting precinct. You might wonder what a lighting precinct would have to do with a zoning case. Well, Kearsarge lighting precinct is a village district that has zoning authority. I believe it's entirely within the town of Conway, or at least most of it is within the town of Conway, but it's a village district that has separate zoning authority. And their zoning ordinance says that all residential properties offering sleeping accommodations to transient or permanent guests shall be owner occupied and operated. Again, pretty clear, shall be owner occupied and operated. And the plaintiffs were operating in several non-owner occupied short-term rentals. The village district sent them notice of violation. They appealed to the ZBA, then to the Superior Court. The plaintiffs threw out every constitutional argument you could imagine. Equal protection, procedural due process, substantive due process, dormant commerce clause, privileges and immunities clause. I'm surprised they didn't raise a claim about cruel and unusual punishment or stationing of troops in homes in peacetime. They claimed an unconstitutional taking, of course, selective enforcement, and it was a legal non-conforming use. of those arguments, the one that seemed like it might be most legitimate was the selective enforcement claim, because they said that the village district is enforcing the ordinance against out-of-state property owners, but not against local residents. Well, the Superior Court affirmed the ZBA decision that they were violating the ordinance. The court said that the property owners had not provided sufficient evidence of selective enforcement, and therefore they were not allowed to operate these STRs. The case has been appealed to the Supreme Court. The plaintiffs, the property owners, filed their brief a couple of weeks ago, and the village district's brief, I assume, is due in another week or two. So that's in the Supreme Court, and we'll see what happens with that. And then the other case, again, this is a Superior Court decision, coincidentally by the same judge as the Kearsarge Lighting Precinct case, Town of Conway versus Kudrick. Town, again, has a permissive zoning ordinance that allows single family, two-family, and multifamily dwelling units, has a definition of dwelling unit, and a single unit providing complete and independent living facilities for one or more persons living as a household, including provisions for living, sleeping, eating, cooking, and sanitation. That's very similar to the one that I gave you earlier from my town's ordinance, the Henniker zoning ordinance, where I said I think that it's kind of unclear and could use some clarification. And I think the Conway ordinance was unclear too, which of course is why it ended up in court. The ordinance in other places defined lodging houses, boarding houses, and tourist homes as providing transient or semi-transient accommodations, and these were not permitted. I'm not going to go through. I have bullet points here as to how the stuff all fit together and how the arguments went. I'm not going to go through that in detail, but the short answer is the court ruled against the town, stating that basically finding that under the definition of dwelling unit was broad enough to include short-term rentals, and because the judge ruled that a short-term rental was a unit providing living facilities for one or more persons living as a household. The town has appealed that case to the Supreme Court, and I believe the briefs have not yet been filed on that. So that's probably several months away from decision by the Supreme Court. Now, different lawyers are going to disagree on this, but I think that the Conway decision is questionable for a few reasons. I think Judge Johnston, would have ruled for the town, but I can see how the judge got to where she did, and it's certainly not a criticism of the judge. And again, it's the same judge who ruled for the Kearsarge Lighting Precinct in the other case. But as I say, the lesson here is clear. Make sure your ordinance has very clear definitions that don't leave any room for doubt. And I'm not critical of the town of Conway at all, or of its zoning ordinance, because the ordinance, as I mentioned, like so many other zoning ordinances, historically didn't define short-term rentals, didn't anticipate the market that we have now, and therefore didn't address them as clearly as it might. I think I've mentioned this before. As you're thinking about this stuff and these definitions, you really need to talk to your lawyer and make sure that you're defining things very clearly. And then last thing I want to talk about is the legislative efforts to restrict municipal authority. And I mentioned at the beginning that I've been involved in trying to stop these over the years. There have been efforts since at least 2017, backed largely by the Association of Realtors and by the industry associations for Airbnb and VRBO and others, to prohibit municipalities from regulating short-term rentals. And their argument is we need a statewide rule on this. We can't have a patchwork of zoning regulations. To which my answer, of course, is of course we can have a patchwork of zoning regulations. That's how zoning works. Every town has its own zoning ordinance, and some towns allow some things and not others, and other towns allow those things but not these. That's the way it works. That's the whole idea. There are a few things that you can't prohibit. You can't prohibit workforce housing. You can't prohibit manufactured housing, although you can limit it to some areas. You can't prohibit the tilling of the soil. But beyond that, there's almost nothing that a town can't prohibit. And why this one use of all uses should be singled out and exempted from all zoning authority is beyond me. But in any event, in 2017, there was this effort to preempt local control over short-term rentals. That effort ended in the law that I talked about at the beginning that merely amended RSA 48A to say you can't use that statute to restrict short-term rentals. There was no effect on zoning authority. So that effort basically failed. In 2020, there was another bill that would have prohibited any municipal regulation. That bill, one of the few good things that resulted from the COVID-19 pandemic was that the legislature had to shut down in March. It might be kind of nice if that happened a little more often. And a whole lot of bills were tabled and then died on the table, and this was one of them. It almost made it through the Senate, but the legislature shut down, and that was the end of it. And good riddance. Then this year there was Senate Bill 249. I'm sure that some of you have followed that. That bill, again, I've quoted there that the main part of the bill, basically it says that any building or structure anywhere in the state can be converted to a short-term rental, and the town can't stop it. Really very extreme. And the municipal association, and while I was still there, I assisted in trying to get that bill defeated. The status is it passed the Senate pretty easily despite overwhelming opposition. Why the Senate passed that bill, even though there was such strong opposition to it, I think the answer is, well, not everything that happens in the legislature happens in a public hearing. It should not have passed the Senate, but it did. I prepared these materials last week before the most recent action on this bill. So I will end the suspense and tell you that the House this week on Wednesday voted to send the bill to interim study. And for those of you who are not familiar with the legislative process, interim study basically means the bill is dead. Dead for this year. There will be a study committee convened in probably September to study this issue and make a recommendation about legislation for next year. But the bill itself doesn't go anywhere. Now, I do say here the danger is not over. There's a possibility of Senate mischief. I think that possibility pretty much ended on Thursday when the Senate finished its action on all bills. Slight chance that something might happen in a committee of conference where someone tries to attach this language to another bill, but I think it's very unlikely. But I would say follow the New Hampshire Municipal Association's legislative bulletin. It comes out every Friday. It's on their website to see whether anything more is happening in that area. In the event that Senate Bill 249 or similar language does pass, and again, I don't think it's likely to happen, note that the question arises, well, what can you do? First, note that the operative language says no legislative body shall prohibit the use of a short-term rental. So it applies only to prohibitions in the ordinance, because when it says legislative body, that means the enactment of a zoning ordinance. So the ordinance can still require a special exception, which is not a prohibition, and it can impose conditions. And when someone goes to the ZBA to get a special exception, the ZBA, if the conditions are not satisfied, can deny the special exception because the ZBA is not the legislative body. So if Senate Bill 249 were to pass, that doesn't, although I think it was intended to, that doesn't actually result in the municipality having no authority whatsoever over short-term rentals. But as I said, I hope it's not going to happen. But follow this issue through the municipal association. And as I think I mentioned before, talk to your lawyer. And you really should start thinking now about amending your ordinance, whether it's to prohibit short-term rentals, whether it's to clarify the ordinance based on what I talked about earlier. As I think you all know, the zoning amendment process is cumbersome, laborious, and you don't want to wait until January to start an amendment process for something that would be voted on in March. You want to start in the summer, especially with something like this that is so controversial and so complicated. And with that, I have come to the end of my presentation. Someone did just put up a question. How time-consuming would the enforcement of business status of temporary housing be for a town? I'm assuming that means enforcement of if you're going to require a municipal permit for short-term rentals. How time-consuming would it be? It could be pretty time-consuming, and so before you do something like that, you might check with those municipalities that have done it. I think I heard something from Laconia about that. If you only have 2 or 3 short-term rentals, it's not going to be very time-consuming. But if you have a lot, it could be extremely time-consuming, and you can, of course, build that cost into your fees. You can require a fee for your municipal permit. So if it looks like it's going to require, hiring an additional part-time code enforcement person or an additional part-time administrative person, build that cost into the fees.
Great. Well, thank you, Cordell, for a great presentation. We do have a few more minutes for Q&A question and answer session. So if you're online and you haven't already done so, you can type your question in the chat or raise your hand to verbally ask your question, and we'll give you the ability to unmute yourself. And for attendees on the phone, let me just check before I read through all this. Okay, I don't actually believe we have any attendees on the phone. I'm going to ignore that part. So if anybody has any remaining questions for Cordell, please, you can feel free to put them in the chat or raise your hand now. Okay, I'm not seeing any questions. I think you covered the material so thoroughly, Cordell, that you've just answered everybody's questions.
Okay,
so thank you so much.
Yeah, again, if anyone has any follow-up questions, my contact information is there, so feel free to contact me.
Great. So thank you, Cordell, for a great presentation. Thank you, everybody, for attending and for the couple of questions we did get. And as Cordell just mentioned, feel free to follow up with him. If you have additional questions, OPD would also be happy to answer any questions, so feel free to contact us as well. The slides for this session are available for viewing and download on our conference webpage, and the link to the recording will be on OPD's YouTube channel by early next week. We welcome and encourage any feedback on the session. My colleague Ken has put a link to the brief anonymous evaluation form in the chat box. That's also available on the OPD conference webpage. And with that, we want to thank you again for attending the conference, and we hope everybody has a great rest of their Saturday afternoon and weekend. Take care, everybody.